So welcome back to our Southern Podcast with me again, Ain here. And today we have another two panels. Welcome, Miss FATIHAH and Mr. IRSYADUDDIN. So say hi.
Hi.
Hi,
Hi everyone.
So are you guys having a good day? Doing well?
very much.
Alhamdulillah. Alhamdulillah. So far by now I'm doing great.
Our podcast today will discuss a few hot issues, I think, regarding Pulau Sipadan and Pulau Ligitan. Do you ever heard this before?
Yeah.
I always heard about Sipadan, but not that much about Ligitan, I think.
So basically, this topic is requested by one of our listener. I think not one, some of our listeners, because they said like, why don't we discuss a new thing regarding international law and something like that.
Cool.
So we decided, our team decided to choose a topic on Pulau Ligitan and Pulau Sipadan, like
Alright.
quite hot issues. Okay, so I think I'll give the stage to Miss Fatiha. So what is your opinion regarding this case?
Okay, my opinion, I think I would like to highlight on the parties' argument first. So at first, we both know that um, at that time, this Pulau Ligitan and Sipadan were actually foreign to both of the countries, and then later was found, and both of the countries are disputing over this area. So on behalf of Indonesia, they claim sovereignty by claiming that they are legit successor to the Sultan of Bulungan.
Oh.
Sorry, my Terengganu slang.
It's okay. I
It's
can understand.
okay. It's
Yeah.
okay. Like Sultan of Bulungan, right?
Yeah, Sultan Bulungan through contract with Netherlands that formerly has colonized Indonesia, which also regard as conventional title holder. Indonesia also put several effectivities. Effectivities is kind of like several of activities done at that particular disputed areas as an action to claim sovereignty over the area. They also heavily depends on Article 4, which is from the convention that you earlier said. You said earlier.
1891
Yeah,
convention.
1891 convention. So this they interpret that this 410 north latitude is not just doesn't end at the end of the area of Pulau Sebatik, but it goes beyond that. So when the line goes beyond that, this just like they said, the southern part belongs to Netherlands. So when southern part belong to Netherlands he who which is the one who colonized the Indonesia. Basically, when it formed the southern part, then it belongs to Indonesia like that. But again, Indonesia said if it were not intended like that, it will be as per mentioned in Article 3. Like Article 3, they literally said that from the end and the beginning. So when there is no like a clear wording that say um, at the end of the north of Pulau Sebatik, then it must be intended go beyond that line.
So basically, regarding the party's argument that you mentioned before, so how the court decided? I mean, what is the judgment of the judge of the ICJ regarding this matter? Whether at the first place, few of the judge said this is belongs to Malaysia, or another judge said this is belong to Indonesia. So how court decided?
So the judgment by having all the arguments as mentioned by Ms. Fatihah previously. So the ICJ with the majority of 16 to 1. So basically there are 17 judges to decide this case in ICJ. So by having a majority of 16 to 1, so they awarded the sovereignty over the Pulau Ligitan and Pulau Sipadan to Malaysia. So now Malaysia has the sovereignty over Pulau Ligitan and Pulau Sipadan, in the basis of effective rights. So as mentioned by Ms. Fatihah,
It's like
meaning
activity, if
the
activity in
activity
that
done,
particular place.
yes, in that place.
In the disputed place.
Why the ICJ awarded the sovereignty to Malaysia is basically based on three reasons. It's not the three reasons. The basis is the effective rights, but based on the argument, we have the argument of the convention, the Article 4, Article 4, Article 5
Yeah,
of the
just mentioned like before.
1891. So the court said that the the what we call the possession of the sebatik is not cannot be said beyond the sebatik. So the convention, the intention of the convention is just until the sebatik, not beyond the sebatik. So when it cannot sit the extent beyond the sebatik, so Pulau Ligitan and Pulau Sipadan cannot be regarded as part of them. So because of that, the Pulau Ligitan and Pulau Sipadan is nobody's own that
Belong to
pulau.
nobody.
Second argument raised by both of the party is due to the succession to resolve this dispute, but there is no contract that Ligitan and Sipadan belong to the Sultan of Sulu and Sultan of Bulungan. So not only that, there is no treaty-based title to the dispute island. So because of that, the court cannot rely on this argument. So due to that, the court by having no argument, cannot rely on that. So the last thing that court take into account to solve this problem is due to the principle of effective rights. So as we know, Malaysia has used the Pulau Ligitan and Pulau Sipadan as one of their tourism attractive, and as we have the regulation of turtle eggs, we have the operation of lighthouse in Pulau Ligitan, and it was operated by Malaysian government. So due to that, the court awarded the sovereignty to Malaysia over the Pulau Ligitan and Pulau Sipadan. But even though we have this reason of the judgment, we have the dicta here based on Judge Oda. There is a curious thing that come into his mind. As we can see that the Pulau Ligitan and Pulau Sipadan has been existed long before 1960. So why at this time they want to claim the Pulau Ligitan and Pulau Sipadan?
Why the sudden claim?
Yes. So due to that, Judge Oda suspected that there is a failure of negotiation to determine the continental shelf, because to get the continental shelf, Pulau Sipadan, the sovereignty of Pulau Sipadan and Pulau Ligitan is one of the crucial thing to give the power of the continental shelf to the party.
So,
Yes.
so basically, you have mentioned before that 16/1, right? The judge that agreed Pulau Sipadan and Ligitan is belongs to Malaysia. So, what is the reason behind their decision, and why there is still like one person, one judge that
disagree with that.
disagree with that? So, can we discuss on that, Miss Fatihah?
Okay, for that matter, I think like Mr. Ishad states that one of the factor that drive these judges to go for Malaysia is like effective rights listed by the Malaysia. Like they give us like a very conclusive, a very strong argument saying this, saying that, compared to Indonesia. But in Judge Oda opinion, it said that several effectivities does not form any definitive meaning or adequate stance. Not really, like bring a very little.
The main
force.
reason, like not the main reason.
Doesn't like give a very clear force that okay, that's because you built this bird sanctuary. It's clearly indicates
Said that this is belong to you.
Yeah,
The whole part
correct.
is belongs to you.
So this judge, like judge or the opinion that it doesn't carry enough weight to draw a conclusion leaning towards either Indonesia, either Malaysia by listed effectivites.
So that's why Judge Oda the only person doesn't
Yeah,
agree with the other 16 judges.
Yeah.
So
One of
in your opinion, I'm sorry, in your opinion, what is your comment regarding this matter basically? Because I think I do agree with Judge Oda opinion at that particular moment, but yeah, maybe you have another comment regarding that matter.
on that effectivites, I couldn't really comment much because very unjust to discount the other country list of effectivities and just focus on this one country list of effectivities. But I would like to suggest on to argue more on, you know, the wording, because I think the wording really give us like a clue, but doesn't give a very clear clue. But
Yeah, so like it's not clearly mentioned to what extent the word is belongs to.
But in this situation, it really gives us a very big headache because both of the countries are disputing over this area due to a very vague, ambiguous wording, because it doesn't clearly provide that, okay, it ends, this boundary line of Pulau Sebatik, it ends at the end of the area of Pulau Sebatik. It doesn't say like that.
There is no specific word that it
Yeah.
can say
But
it can be on this Batik Island.
Yeah, but I think all in all, Indonesia cannot arbitrarily invoke that the boundary line from Article 4 extensively continues even beyond the area of Sebatik. And then punctuations. I would like to comment on that. Punctuations, I think it's more reliable to depend on the Dutch version because it used semicolon instead of colon in English version. It thinks that one sentence as like this, there is two sentences, but they are connected in a logical sense. It is not like a two sentence that brought one meaning. It's two sentence and consolidated by one punctuation, but still, they can stand alone. They can stand alone without the semicolon, something like that. Interpretation from Malaysia is more accurate as it is more plausible. The second sentence after the semicolon describe particularly on the position of Sebatik. It doesn't like describe as a whole, like from 410 north. It's like doesn't describe as, like the whole part of the Borneo. It's described only on the Pulau Sebatik. So it ends at the end of
The
the
Sabat.
area of Sebatik.
So I can say that basically in my view, in my personal view, Malaysia got Pulau Sipadan and Pulau Ligitan is based on one of it. The main contribution is on part of the technicalities, right? The technicalities.
Actually, they argue on that.
They argue on the technicalities instead of like regarding the facts that maybe regarding the activities development that they had made on that particular island. So I do agree about what you have been mentioned before, but one thing that we can see from these cases is like we managed to have Pulau Sipadan and Pulau Ligitan without having a war or even a bloodbath. So we got it in a peaceful means, fair and unprejudiced, and we still have a good.
words.
And because of that kind of dispute, we still have a good relations with Indonesia. So I think we have reached our time, and thank you for having us, Mr. IRSYADUDDIN and Miss Fatihah. Yeah, maybe see you soon and see you in another episode. Bye bye.
Thank you all. Bye.